Hello, everybody. My name is Dominik Müller. I am a professor of cultural and social anthropology in Germany at the University of Erlangen-Nuremberg. I have been a visiting fellow with the program on law and society in the Muslim world here at Harvard Law School. And today, on behalf of the program on law and society in the Muslim world and the director Kristen Stilt and associate director Selma Wahidi, I am very pleased to welcome you to this webinar. Thank you to everyone who is joining us from the Harvard community, as well as to our participants from all across the world. Just a bit of housekeeping for the folks tuning into our webinar today. So our audience will be muted throughout the webinar. The event will be recorded and it will be made available afterwards through the program's social media platforms. You may enter your questions in the Q&A box at any time during the talk and after the talk, and we will try to get to as many as possible of those questions. We apologize in advance that we won't be able to answer all questions. And I'm very excited to introduce our speaker today, Dr. Nurul Huda Muhammad Razif. Dr. Nurul Huda is an anthropologist specializing in gender, marriage, and intimacy in the Malay world in Southeast Asia. She holds an Evans Fellowship from the University of Cambridge, and she's currently also a postdoctoral researcher at the Center for Southeast Asia in France at the School for Advanced Studies in the Social Sciences, the EHESS in Paris. She received her PhD in social anthropology from the University of Cambridge in 2018, and she held a visiting fellowship here at the program on law and society in the Muslim world from 2019 to 2020. Before her work with the program at Harvard, she has also held fellowships in the Netherlands at the International Institute for Asian Studies and at the Royal Netherlands Institute for Southeast Asian and Caribbean Studies, the KITLV, which are both located in the beautiful town of Leiden. Her work has appeared, for example, in Hawa, the Journal of Women of the Middle East and the Islamic World, and in the Asian Studies Review, and various writings are also forthcoming, including a monograph that is related to her presentation today. She has conducted extensive fieldwork in various parts of Malaysia and also across the border into southern Thailand, for example, in Syariah courts, in Islamic bureaucratic institutions, among polygamous families in their everyday lives, but also in various other settings. The title of her talk today is Holding Marriage Hostage, Male Guardianship in Muslim Women's Application for Marriage in Contemporary Malaysia. Nurul, I'm going to turn it over to you now.
Thank you very much, Professor Dominik Müller. And hello, everyone. Good evening or good afternoon, depending on where you're logging in from. First of all, I wanted to thank you, Salma Wahidi, for this invitation to speak and to return to the program on law and society in the Muslim world to share my research. And I'm also very grateful to Professor Dominik Müller for that kind introduction and also for agreeing to chair this talk. And of course, thank you to all the members of the audience for joining in from wherever you may be. Very pleased to be here, and I hope this will be an interesting discussion. So as Professor Müller mentioned, I'm a social anthropologist by training, and I work on the intersection between intimacy, Islam, and the state in Southeast Asia. My primary field site is the peninsula, the Malaysian peninsula, and I've worked extensively on the Malaysian-Thai border, and also the province of Songkhla in southern Thailand, where I started my research by studying Malaysian couples who eloped to Thailand to contract cross-border marriages for various reasons, such as bureaucracy, as I will also explain in this talk. And then I moved my field site to the state of Kelantan in the northern part of Malaysia, where I studied the marriage registration cases of these elopements. And also alongside that, I studied other kinds of cases concerning family law in the courts, including the Wally refusal case I'll discuss today. And then I also did research in Kuala Lumpur and also the state of Negeri Sembilan, down here, living with a polygamous family to capture the everyday dynamics of this very interesting form of marriage. So before I dive into our topic today, I'm conscious that I may be speaking to an audience that might not be familiar with Malaysia or Southeast Asia. So just to give a quick overview, Malaysia has a population of 32 million people, and it's ethnically and religiously very diverse. The ethnic majority in Malaysia is the Bumiputra, which is an ethnic category which literally translates into sons of the soil, which includes the Malays and also the indigenous groups of Malaysia. And they make up about 62%. This is followed by the Chinese, who make up about 21%, and then Indians, and we have also non-citizens who are mostly migrant workers working in the service or industry sector. In terms of religion, religion and ethnicity significantly overlap in Malaysia because according to the constitution, every Malay is by default also a Muslim. So we have a comparable number of the population who are Muslim, about also around 60%, followed by Buddhists at about 20%, Christians almost 10%, Hindus at 6%, and other animist religions at 5%. Islam is also the official religion of Malaysia. And we have a very extensive Islamic bureaucracy comprising not only the Syariah courts, but also federal and state level Islamic authorities that administer basically nearly every aspect of Muslim life. But that in itself is a whole different talk. So to accommodate the ethnically and religiously diverse population, Malaysia has a dual legal system in place, which was first established under British colonialism. First, we have the civil law, which is based mostly on English common law, and it's applicable to all citizens of Malaysia, except where it concerns personal status for Muslims. Now that falls under Sharia or Islamic law, which is concerned with marriage, divorce, inheritance, child custody, and it applies exclusively to Muslims. And Sharia law is also branched into Islamic family law, and then we also have Sharia criminal law, which is more concerned with things like forbidding people from consuming alcohol, gambling, and also protecting the sanctity of Islam, which is a very, Sharia criminal law is a very extensive subject on its own. So as Malays are predominantly Muslims, much of my research on Malay marriage was conducted in Malaysian Syariah or Islamic courts, where I observed marriage registration cases, divorce cases, polygyny applications, and wali refusal cases, which I'm going to be discussing today. But before I get into that, I just wanted to say that the most interesting part of being an anthropologist studying marriage is being able to attend weddings, which, like anywhere in the world, are always a joyous occasion. I want to draw your attention to this photo, which was taken after the solemnization ceremony in Malay called the nikah of a Malay couple that I knew. In this photo, the bride and the groom are shaking hands, and this open display of physical touch signals to the public that they are now lawful to each other as husband and wife. The bride is kissing the groom's hand, which acknowledges his role as the head of the family and her obedience to him as a wife. In the background, her female relatives are looking on in joyous approval, I would say, as they celebrate not only the union of the couple, but also the transition of the bride into adulthood and womanhood as she goes from being a daughter to a wife. And if you look at the sides, the solemnization ceremony also includes the exchange of gifts between the brides and the groom. Here on the left side is a frame containing a check, which is the bridal payment from the groom to the bride, which at the current rate goes from or anywhere from 10,000 ringgit or about $2,000 US to anywhere beyond that. If you see in the next photo, other gifts are also exchanged on the side, like a shirt for the man, perfumes, handbags, shoes, all various kinds of gifts. And in this photo, the groom is the one who is kissing the bride's forehead, which shows, which symbolizes that he will be her protector in a way in the marriage. But all these gifts exchange in the marriage is mostly a cultural practice in Malay adat. Not really, it's not really an Islamic requirement, because what matters more in the requirement for marriage in Islam is the permission of the bride's wali or male guardian, who must consent to the union. So about 50 to 60 years ago, marriage by parental arrangement was probably more common among Malays. But Malay parents today would prefer to have their children find their own spouse and to marry based on love, mutual attraction, and social compatibility. So, they would find spouses, their future spouse in their workplace or in the college where they studied. Not really, unless they are unable to find a spouse, then they would ask for the help of parents to suggest a spouse. But it's very rare for parents to force their children to enter into marriages. So according to so the parents' blessings are not only important for ensuring a blessed union, but under Islam and Malaysian Islamic family law, no marriage can be contracted without the consent of the bride's male guardian, so her wali, who is usually her biological father. But as I will explain next, there is a list of who is qualified to be a wali. For the most part, fathers would be very happy to consent to the marriage if they know that the spouse, the prospective groom, pardon me, is a man who has an earning potential, who comes from a good family. But there are cases where the wali may refuse to marry off his daughter because for example, they're too young to be married, or because she intends to marry a married man as his second wife. So if it's a polygamous marriage, then very likely there will be objection from not only from the father, but also from her family. In this case, if the wali refuses to consent to the marriage, the women may lodge an application for a replacement wali on account of his refusal. And it is this moment of tension and conflict in the path towards marriage that I wanted to explore today. So one of the wali refusal cases that I observed when I was doing my research in the Islamic court, the Syariah Court of the State of Kelantan in Kota Baru, which is pictured here, concerns a plaintiff who was a young Malay woman in her mid-20s, whose wali, her biological father, had refused to sign his permission on her marriage application form. And this is the courtroom where this is all happening. So the judge wanted to hear whether his refusal had come with good cause. The father, who is the defendant in this case, told the judge that his daughter had not sought his permission with the respect to marry, with the respect due to a father. In fact, he said that she had come to see him one night at a coffee shop and had just brought a blank piece of paper instead of the whole marriage application. So the judge was appalled to hear this story, and he rebuked the defendant for not approaching her father with what he calls adab, which means good manners. And he also became increasingly disapproving when he heard that the plaintiff had been working and earning for some time, but had never contributed any money to the father or made the effort to visit him more. And he said, as the daughter, you should go to see your father at his house and bring with you a bag of rice or some offerings. And the plaintiff did not take this advice very quietly. In fact, she challenged the judge by saying, why should I go to see him? Since I was young, he has never cared for me and he has only come to visit me twice. The judge surprised and angered by her insolent reply, responded by throwing her case file across the room. And as you can see, this is a very big courtroom. After a moment of silence, the judge had told the plaintiff to learn some manners and to ask her wali for permission again. So he had neither approved nor rejected her her application to have a replacement wali. In fact, it was clear that he believed her wali, who was her biological father, should retain his rights to decide his daughter's future marriage. The judge's response shocked everyone in the courtroom, especially the plaintiff's elderly relatives, female elderly relatives who were sitting in the back of the courtroom with me at that time. One of her aunts explained to me that the plaintiff's parents had divorced when she was very young, and she was raised by her aunt's family. And this is not, it's actually not an unusual arrangement for children of divorced parents in Kelantan. But her father had never visited his daughter nor contributed to financially to her upbringing. Apparently, when she had sought his permission to marry, he had asked for a sum of money in exchange for his consent. And this, according to the aunt, was why the plaintiff had decided to seek an alternative wali through the court. So in this talk, I want to use this ethnographic episode I witnessed in court as a point of departure for thinking about two important issues. One is, the first is this dissonance between the Islamic concept of male guardianship as imagined and practiced by the Malaysian Syariah judiciary and the lived realities of Malay kinship. As this episode in court has shown, both do not always map neatly onto one another, creating tensions that raise questions such as who can be a wali and what are the rights, roles, and responsibilities of one? How is the Islamic concept of male guardianship interpreted through the lens of Malay kinship? And finally, what happens when men fail to uphold the role of male guardians? So the role of male guardian or a wali in Islam comes from the concept of guardianship or wilaya. And this is defined as the legal authority vested in a person who is fully competent to safeguard the interests and rights of another person who is incapable of doing so independently. There are two types of guardianship recognized by Muslim jurists. The first is wali which is the guardian with authority over a general population, such as a sultan or the head of state, and wali nasab, which is the guardian who has authority over specific individuals based on nasab or patrilineal blood relations. So this includes fathers having guardianship over daughters until their moment of marriage, at which point the guardianship role transfers to her husband. A wali invested with such authority is without exception always related through the patrilineal line. And a woman's default wali is always her biological father, but if he is deceased or has disappeared, the role of the male guardian would fall to her paternal grandfather, and failing that to her brother of the same mother and father, and followed by a string of more and more distant male relatives. And more importantly, the wali is also always a male. This reflects the hierarchical system of gender relations in Islam more broadly, which typically places men in a position of higher authority than women. And one of the Quranic verses that have been used to justify this comes from Surah An-Nisa, which is the 4th chapter of the Quran, which is translated as men are the protectors and maintainers of women because Allah has made one of them excel over the other and because they spend out of their possessions to support them. Now, it would take another talk to discuss the theological interpretations of this one verse alone. But I just want to highlight two predominant but competing interpretations that are very common in gender discourses. And the first interpretation promoted by many male scholars argues that this verse demonstrates men's physical, intellectual, and spiritual superiority over women. And this idea has been used to justify various contentious issues such as men's supposedly divine right to practice polygyny. But Muslim female scholars have challenged this interpretation, saying that it is not authority that God gives men over women in this verse, but rather the responsibility to ensure and protect women's socioeconomic well-being. And indeed, this is one of the reasons why why the wali is appointed as the woman's representative in marriage. First, his role is to confirm that there is compatibility or kafa'ah in the match in terms of factors such as religion and character. And second, he should check that the match will ultimately serve in her well-being and in her best interests, called her maslaha, the maslaha. And some Muslim majority countries such as Morocco, Egypt, Iraq, Turkey, Tunisia, and Afghanistan do not require women, brides and grooms of legal marriageable age to have the consent of the wali to marry. But this is not the case in Malaysia, where state Islamic family law enactments throughout the country requires the wali's consent for marriage. So for example, in the state of Kelantan, the Islamic family law enactment here explicitly states that a marriage shall not be recognized under this enactment unless both parties to the marriage have consented thereto, and either the wali of the woman has consented to this marriage, or the Sharia has given consent to a wali raja, which is a replacement wali appointed by the judge, in situations where there is no wali by nasab, which means that there are no living male blood relatives. In cases where the wali cannot be found or is presumed dead, or if the wali refuses his consent without sufficient reason. And so this is what most wali refusal cases are about. If the wali refuses his consent and the judge has to decide whether that his refusal is justifiable or not. Official state Islamic authorities in other states have also drawn on other sources of Islamic law, such as the hadith or the sayings of the Prophet, to justify the indispensability of a wali before a woman may marry. So for example, this hadith has been used by the Kuala Lumpur's official state Islamic authority to justify why a woman cannot be, a woman needs a wali to marry. And this hadith says, any woman who is married or enters into marriage herself without the permission of her wali, her marriage is void. And even if a woman may seek an alternative wali through the court, state Islamic authorities nevertheless advise that every couple seeking to marry must respect and prioritize the wali akrab, which is the closest male blood relative with the rightful authority to be a wali, who is her, usually her biological father. This is to preserve familial harmony, according to this statement. And so we can see that the official Islamic authorities' position on the wali is very clear. The first is that a woman does not have the capacity or authority to enter into a marriage contract herself, and therefore the requirement of the wali in her marriage is non-negotiable in Islam and under Malaysian Sharia law. And finally, respecting the position of the wali is not only an Islamic obligation, but also a familial one between fathers and daughters. This final point is significant to note, as it not only shows that the Sharia protects and strongly upholds the role of the wali as a condition for women to marry. More importantly, it conflates guardianship with kinship by assuming that the two categories are one and the same. So in the next section, I will move to a discussion on Malay kinship to show why we must not be so quick to assume so. Okay. While the wali's authority may be enshrined in Islam and Malaysian Sharia, Malaysian Islamic family law, according to Malay culture and traditions, collectively known as adat, paternal authority is an earned rather than a given category. To understand this, we must first return to some of the foundational ideas of Malay kinship. Some of the earlier anthropological studies of kinship among Malays have indicated that blood relations do not necessarily translate into kinship ties. The work of the British anthropologist Janet Carston, who studied kinship in a Malay fishing village on the island of Langkawi, here located in this map, in the 1980s, tells us a lot about how Malays build kinship based on what she calls relatedness. This is the idea that Malays are not born kin, but rather they become one through marrying, living, and feeding together. According to Karsten, everyday rituals such as commensality, which is the act of eating together, creates shared blood that then becomes the substance of kinship. Malays' approach to kinship through relatedness is a significant departure from Islam, which defines bloodlines exclusively through patrilineality, that is the affiliation through the father's line. By contrast, Malays tend to follow a bilateral kinship system, also practiced in Southeast Asia more widely. In the bilateral kinship system, the ego accords an almost equal sense of belonging to both parents. Neither the father nor the mother, nor the mother's lineage claims a stronger affiliation to the child, and relatives from both parents are equally valued. Malay's flexible approach to kinship also means that familial ties are not necessarily determined by biology, but must be socially cultivated over time through the rituals of living together. To return to the court observation case I presented earlier, the plaintiff's female relatives made it clear that they did not recognize the man's social position as a male guardian, as he had never made any emotional or economic investments in her upbringing as her father. One of the aunts said this to me. Since she was young, after her parents divorced, I and another aunt had raised her. Her father never cared for her. He never gave her any money. So for my Malay interlocutors, paternal blood relations to a child is insufficient to qualify a man to be a wali. It is by performing the role of a father that a man's paternal rights and authority as a male guardian becomes socially recognized. So what we see here is thus two models of social relations that converge in a rather contentious manner. While Malaysian Sharia law attempts to enforce the institution of male guardianship based on blood and patrilineality, Malay women, on the other hand, draw on cultural ways of relating and creating kinship that are based on responsibility and reciprocity in social relations. As a result, many Malay women find that the institution of male guardianship loses its purpose to protect their rights and well-being, especially when it is not substantiated by love, compassion, and obligations between father and child. And also, the wali's predatory attempt to extract money from his daughter in exchange for his consent further shows how male guardians can easily abuse this authority, particularly in cases of estrangement. Male guardianship can create precarious power dynamics that exacerbate the age, gender, and generational hierarchies between fathers and daughters, which can delay or deny women their access to marriage. Now this, sorry, I had to catch up with the presentation. So this non-negotiable requirement of getting the wali's consent to marry has compelled many Malay women to seek alternative ways to bypass this bureaucratic obstacle, and that is by eloping to southern Thailand. Here, they may marry in one of the 5 Islamic committees in the region that is authorized to marry Malaysian couples, and these are Yala, Patani, Naratiwat, Songkla, and Satun. And they can return to Malaysia to register this marriage. A cross-border marriage in Thailand still requires the presence of a wali. But if the nikah, the marriage takes place more than 92 kilometers from where the wali is physically located, then the woman can appoint the marriage officiant as her replacement wali, as a substitute for her wali. So this relieves her of the condition to first inform her wali or her father of her intentions to marry, and second, to obtain his approval for her impending marriage. And most of the women who elope to Thailand would rather not tell their wali about it, because either they're marrying at a very young age, as I mentioned before, parents are very unlikely to approve of this marriage, or because they are marrying as a second wife and would prefer to keep the marriage not only a secret from their wali and their own family, but also a secret from the first wives. And that is one of the major motivations for eloping to Thailand, where they may marry more discreetly. But the possibility for women to bypass the wali requirement makes eloping to Thailand preferable to marrying in Malaysia because of the less bureaucratic demands for marriage. And more importantly, this backdoor to marriage grants Malay women greater autonomy to chart the course of their marital fate, including to make risky decisions such as to marry as polygamous second wives. Okay, now to come to some concluding thoughts. So to conclude, I've shown how the institution of male guardianship in Malaysian Sharia law at times does not take into consideration the everyday relations and realities of Malay kinship, which recognizes that paternal authority is an earned rather than a given right. While judges could and technically should suspend the authority of the wali if there is evidence of coercion or maltreatment, this process could be hindered by gender biases in the judicial process, as well as textual readings of Islamic law that sanctify male authority without considering the nuances of Malay kinship. The familial conflict arising from the wali requirement to marry could also be read as a consequence of a historically high divorce rate in Kelantan. And indeed, most recently in 2019, it was listed as the third highest state in Malaysia with the highest divorce rate after Selangor and after the state of Selangor and Johor. Children of divorced parents are usually raised by their mothers or close relatives, as was the case with the plaintiff earlier. And fathers, in this case, would typically play a socially distant or even absent role. And this leads to estrangement that becomes rather awkward and problematic for women who then have to summon a wali that they have never known intimately before to fulfill this symbolic role of a guardian to hand them over in marriage. And finally, I see this tension on male guardianship in the Malaysian Islamic family law as being a product of the bureaucratization of Islam in Malaysia more broadly, which subjects various aspects of everyday life concerning Muslims to various laws and state regulations that are very complicated. As a result of this, marriage too becomes a heavily bureaucratic affair involving various paperwork and procedures and requirements that prevent couples from marrying easily. This leads to a higher demand among Malay couples to contract eloped cross-border marriages in Thailand, which can actually result in very precarious marital circumstances for women as well. So the requirement for a male guardian is one of the factors that make marriage more inaccessible and difficult for Malay women today. If it were intended to protect women's rights and interests, it should not place women in an inferior position which considers them as intellectually, emotionally, and economically incapable of making decisions on their own match and marital future. Rather, the Islamic judiciary and the wali appointed by blood or by law should serve to empower women by honoring the progressive position they have secured in all other areas of life. Today, Malay women are able to pursue higher levels of education compared to their male peers. They're able to occupy professional and managerial positions in a competitive labor market. They can earn for their families, all the while serving as the primary caregivers at home for parents and children. And Malaysian Sharia law should exist in conversation or take seriously into consideration the plight and circumstances of Malay women in their everyday life, where Islam is but one of a constellation of moral systems that guide them, which adat is part of that. So That's all for me. Thank you very much for listening, and I look forward to your questions and comments. Thank you.
Thank you so much. That was very insightful, very interesting. And actually, each time I'm attending your presentations and talks, I feel like I'm learning something new again. So it's really fascinating how much facets and actually sub-themes you have within that larger project. Now, we do have a few first questions in the Q&A, and I would like to encourage the audience to add more, but following the customary law of the program, so to speak, I will ask the first question. And that is related to the concept of and the role of the wali, the guardian. And I'm curious, I mean, you have described the role of the guardian in the context of the Malaysian Sharia legal system, especially in the context of marriage. But I would be curious, does this concept of the protector, of the guardian, also play into other realms of social life and into possibly, I mean, other areas of social life beyond the confines of marriage? Could you maybe give, if at all, I mean, could you give some examples on that? And maybe I can add a second question also, and that's that the notion of the best interests, the maslahat that you mentioned, and maybe you could give a bit of an example, like how in the kind of the messy realities on the ground that you observed, what we can actually imagine that to be, how that plays out, and maybe also how that is contested then, what it actually means. Maybe you could elaborate a little further on that. Thanks.
Sure. Yeah. Thank you for these great questions. On the first one, is the wali a requirement in other aspects of life? And that is, I would say no, because Malay women, thanks to their, the freedom accorded to them in adat, they have always been able to go out and be very mobile in their everyday life, go out and earn, in the fields or in higher managerial positions. So, even though the state Islamic authorities encourage women to gain the permission of their fathers or husbands before they do something, it's not, it's generally very easily negotiated. But it is at this point, before a woman is about to marry, that a wali's role becomes concretized and indeed, is institutionalized in Sharia law. And this is why the young women that I described can go on living for like 20 years of her life without ever having to face her father up until this point. So this is why wali refusal cases are very interesting, because it kind of takes into it tries to concretizes a role that has never been lived in some women's everyday reality. So this is why some of my Malay female interlocutors would differentiate the role of a father and a wali. One is, both should ideally complement each other, but to enforce, the male authority of the wali without earning the respect of a father, this is quite a difficult thing to digest for many Malay women. And the role of the wali can also be complicit in allowing some phenomenon to, such as child marriage, to perpetuate, because even though in some states in Malaysia, the minimum age for marriage for girls are 16, but in Selangor it has been raised to 18. If the wali consents to the union, they can get married at 15 or 13, and this is quite a concern, because how does the wali understand what a woman's what the girl's best interests are? And in this case, it's and does a young child at that age, is she able to consciously make a decision to marry? And all of these questions come to mind. So, and this leads us nicely to your second question on what best interests mean. Another wali refusal case that I observed in the same court is that the wali had refused a woman, his daughter's application to marry a man who was involved with drugs. And so he had rejected that he didn't consent to sign it. So the judge interrogated her and asked, are you sure you want to marry this man, knowing that he is involved in drugs and will possibly, not be a good match for you as a husband? And are you sure that he did not coerce you into getting this permission? And so the bride, the prospective bride, confirmed that, yes, this is my choice and I want to do this. I know what I'm getting into. And so he allowed her to marry the man. So in some cases, the wali understands that, tries to guide the woman to go for a more suitable match. But in the end, I would say, like, the most Malay women are able to marry the match of their choice. Yeah, I hope that answers.
Yeah, absolutely. Thank you. I have several more interesting questions, and I'll just start with this one. And it pertains to something that I also had in mind, the theme of legal pluralism or legal plurality, multi-normativity, you might call it, like the coexistence of different normativities and their relationship. I mean, the concrete mode of legal pluralism. So the question is, and also, I mean, the Malaysian kind of setting, the fragmented setting of the Malaysian Islamic bureaucracy and the Malaysian Sharia judiciary. So the question is there a hierarchy of law between Adat and Islamic law in that context? Do Sharia court judges prioritize Adat over Islamic law or vice versa, depending on particular circumstances? Does it differ from state to state in Malaysia?
Oh, okay. That's a very interesting question. And I would say the Sharia law definitely takes precedence over Adat, because Adat doesn't have enactments. It's not codified. But Sharia law does include elements of Adat in it. So it's a very dynamic and flexible, it's like a sponge in a way, because like, for example, even though in Islam there is not really a particular ruling on the division of the equal division of matrimonial assets, the Malaysian Sharia law does absorb this practice from Adat and codified it into Sharia law. So husbands and wives are able to, both spouses can claim matrimonial assets from each other under Sharia law, even though that is traditionally an Adat practice. So definitely Islamic law takes precedence over Adat, but at the same time, having observed these judges and the way they reason their rulings and interviewed them, I would say that they draw on a lot of ideas of Malay personhood and kinship relations from Adat as well. So even though it's not really stated in the enactments of the books of the enactments, nevertheless you can still see that Malay cultural ideas about living together, about gender relations can sometimes permeate in their ruling. And I would say that sometimes Adat and Islam complement each other and overlap a lot, that it's kind of hard to say which one is Islam and which one is Adat. So historically, this has always been, Malays have always practiced a fusion of the two. So it's very interesting to kind of see how these two normativities kind of interact with each other inside the courtrooms and also outside in everyday life. I think there's a third part to the question that.
I mean, does it differ from state to state? I think that was related to the federal structure.
The Islamic family law enactments and Sharia criminal laws from state to state are generally quite uniform. There are not like significant differences from state to state. But it's hard to say as well, because I've only studied the courts in Kelantan and Selangor and Kuala Lumpur. So I would require more fieldwork to answer that adequately. But thank you for the question.
Thanks. So the next question is again an empirical question. What stigma or negative consequences might a Malay woman face for taking her wali father to court, even if the case is decided in her favor. So even if she wins, might she lose? And what kind of implications does that have?
Yeah, okay.
I mean, maybe from your personal experience and observation also.
Yeah, another great question. Thank you. The stigma can come on, the woman herself may face stigma for acting in a very rebellious way towards her father, in a sense, because he is, in a way, she is also shaming him for not being a proper, father by taking him to court. But at the same time, when in the court setting, you can see that the judge would typically be more biased towards the father, the paternal authority in question, as this judge had been. So, but generally, if there are reasons behind the woman's decision to take her wali to court are justifiable. For example, like other people have known that the father and child have never been particularly close, or that the father may have ulterior motives for refusing to consent to the marriage, then the stigma might not be too great. But for the father, it could. It's hard to say, because from what I have been able to observe, it seems that the judge definitely kind of upholds paternal authority. Even so, he didn't even give the women, in this case, a chance to explain why she was in court. So, why she had decided to ask for a wali hakim. In fact, only the judge's, the father's side of the story had managed to come out. Before he reacted so violently and ended the case. So in this case, he was adamant that she fulfilled her end of her obligations as a child, and he didn't want to know that the father had been absent for 20 years and all this, and he was the one who told her to bring the bag of rice, which is the substance of what Malays eat every day. So that is the substance of kinship. But for her, she refused to do it because she was like, why should I reciprocate an effort that has never been made towards me? So, so in a way, the stigma here, it might seem to the judge that she is the one who should be ashamed of her actions, but the others, people who know her side of the story, are able to sympathize and kind of understand the logic behind taking a father to court. Yeah.
Thank you. The next question, and in that case, I'll say that it comes from, because she refers to her own work, from a current PLS fellow, Federica Sona. She writes that when observing Sharia councils in the UK, I saw the validity of marriages being disputed by some family members in case a local imam or sheikh did act as the bride's wali instead of the bride's father or grandfather. Would this also happen to Islamic contracts perfected in southern Thailand? Thank you. And yeah, so that's from Federica.
Yeah, thank you for your interesting question. Yes, the wali has the right to object to the validity of the marriage based on the fact that I as a wali am still alive. Why is she allowed to contract another marriage elsewhere? So, so this is so in this case, this would occur usually during the marriage registration case after the couple has returned to Malaysia, and the judge in this case would check to see, like, at 2:45 p.m. when this marriage was contracted, where were you and where was she? So, and then they would kind of like decide whether the 2 marhala distance, which is an older a measurement of distance, which is interpreted to be 92 kilometers, it has been fulfilled. So if it's less than 92 kilometers, for example, the father happened to be right at the border, and and the Thai town or mosque where they got married was not very far, then the judge may say that marriage was not valid, and therefore you need to separate and remarry in Malaysia. with the Malaysian Islamic authority. So in this case, the wali can dispute the validity of the marriage. And then there are also other cases that I've read in the court archives in marriage registration applications files. And some of it also involved a wali disputing the validity of the marriage, saying that my child or my daughter was coerced into this marriage through sorcery or black magic, and she was not conscious that she had been taken to Thailand, almost like a kidnap marriage situation. But the conclusion to such cases that I've read, and there are not many, only two in the few years that I looked into, the conclusion was that the marriage fulfilled all the requirements of an Islamic nikah, and therefore the wali does not have the right to dispute the validity of this marriage. And so even though there was evidence of physical and psychological abuse in the marriage by the new husband, the judge decided to let the marriage continue as it is. So the wali was not able to dispute this marriage in this case. So yeah, the wali can intervene after a marriage has taken place. Yeah.
Okay, thanks. The next question, I think, is interested in methodology and positionality. So may I know, how did you get access to the courtroom for observation? And would you position yourself in your research as an outsider or as an insider, or maybe as a combination of both? Can you elaborate on it? Yeah.
Okay. Wow. Okay. Thank you. That's a great question. How was I able to access the court? I started by asking for permission from the management. And when it didn't take very long. Once they knew that I was doing research for, at the time it was for my PhD, they were very, very helpful very helpful and very cooperative. And I got a letter that basically, gave me access to the court archives, to the registrar's office, and I could approach anyone that I wanted to interview. But I had to approach individual judges for permission to sit in their courtrooms, especially if the cases were happening in the judge's chamber, which is very closed courtroom situation. But if it's in the public courtrooms, like in the photo that I showed earlier, then that's open to the public, and I didn't really need any permission for that. But if I wanted to go into the courtroom, the judge's chamber, I needed his specific permission, even though management may have given me the green light. So that was something that I had to negotiate with each judge. And one judge actually denied me access to his courtroom, and that turned out to be a blessing, because then I had to sit in with the people, the litigants waiting for their turn to see the judge. And I actually got more interesting stories from them rather than sitting in the judge's courtroom, which, like I wouldn't have known the backstory to the Wally refusal case I introduced in the introduction if I hadn't sat in the back room, next to the relatives. And, so that was actually more interesting than sometimes than being with observing the judges themselves. And in terms of positionality, even though I am Malay and Malaysian, I'm not a native of Kelantan. So I come from another part of Malaysia that speaks a whole different dialect, so they can definitely see that I am an outsider. And in a way, even though I could speak and understand very well the Kelantanese dialect, which is quite, to those not familiar with Malay, it's quite it's very different from standard Malay that most of us speak. So even though I speak and I understand that very well, sometimes I prefer not to let that be known, because when my informants knew that I was actually from outside of Kelantan, they were more trusting of me. In a way, it was because, oh, you wouldn't be part of my social network, so I can tell you, things about my marriage that will not go will not, be disseminated to my, my wider network. So it was good to kind of be insider and outsider. Insider in the sense that I look Malay and I dressed in the local way, and I wore the headscarf, which facilitated my access to court. But being an outsider also opened up new possibilities for communication and trust with the people that I met. Yeah.
All right, thanks. We have the dilemma that we have an enormous amount of questions and comments. So I would suggest that, the people who, as I said in the introduction, whose questions I cannot pose now, they might contact you via email, and we will definitely let you read all the questions and suggestions. But let me take a last one, and maybe we can add 2 short ones, and you can see whether you can still address them or not. So because the first one is a bit longer. That's also from a PLS fellow, Andrew Bush. The nice description of a tension between Sharia and kinship described here prompts me to think about the tensions within Sharia. When women seek replacement walis in Thailand, do they describe this as resorting to kinship rather than resorting to Sharia? Or do they see their efforts as actually fulfilling the vision of Sharia? Is it commonly known, is it commonly known that Hanafis do not require a wali for mature women to marry, or that, as mentioned, it is not required in other Muslim countries? On these grounds, it seems possible to imagine that women might insist that the circumvention of the Malay state was very much in keeping with Sharia and Malay adat. So that's that question. And maybe the 2 short ones that I add would be whether there are female Islamic judges in Malaysia, and we can already say yes, and whether that has an impact on how they deal with those cases, and whether the third one would be whether you have any knowledge on the percentage of elopements to Thailand of women who marry a single man rather than. So that's questions.
Okay, great. I'll try to address them all, but I'm sorry if I have to, be very brief. And the first long question by Andrew, thank you, Andrew, is very interesting because yes, legal scholars know that under Hanafi Islam, Hanafi's branch of Islam, adult mature women don't need a wali. But nevertheless, this is not a common, it's not what lay women would know, and how they wouldn't know how to challenge that in court either. So that's one of the things that is quite interesting, in the sense that, on one hand, they are still kind of they, as in state Islamic authorities, constantly reinforce the indispensability of the wali, that they need to have a wali no matter what, even when they elope to Thailand. So in this sense, when they acknowledge marriages that are eloped marriages to Thailand that are consented by a replacement wali, they have kind of had to adjust some of their bureaucratic restrictions to include new kinds of new ways of marrying, in a way. So sorry, the question was quite complicated, and I'm losing my train of thought. But all I can say is that it's very interesting, your observation on the tensions in the Sharia. I would say that for the most part, the Malaysian Islamic authorities still follow Shafi'i Islam. And even though they say that, yes, we may kind of, allow you to have a replacement wali, they will still be kind of, this is the ideal situation is you should still ask your father for, for permission to marry. And the second one, please remind me. The female judge. Yes.
Yeah, the female judge and the percentage, but very brief answer, please.
Okay, great. Percentage of eloped corresponding marriages that are monogamous, it is definitely higher than polygamous ones. Off the top of my head, I'm sorry, I can't think of the numbers, but I could invite you to look at an article that I've just published on corresponding marriages, which would have these statistics on I believe I differentiated between monogamous and polygamous ones, and yeah, so it's definitely on the rise, but it's far outnumbers polygamous ones. That's all I can say for now. Yeah.
Great, thank you very much. So then I would like to thank you, Nurul, thank our wonderful guest speaker today for the very interesting talk and the insightful answers. I would also like to thank our audience again for the engagement and the excellent questions. And I really feel terribly sorry that I haven't been able to kind of read more of them because they were really good. Many thanks to the Program on Law and Society in the Muslim World, the PLS, for organizing this. And yeah, so stay tuned for our future webinars. You may want to check our activities also at our social media platforms on Twitter, on Facebook, and on YouTube. I think they were just posted also. And there was also an email address posted where you could still send your questions and they would be forwarded to the speaker. Special thanks to those behind the scenes who made this possible and who kind of made sure that the infrastructure and everything goes well. We look forward to welcoming everybody to the next sessions of the program. May you stay all safe and healthy wherever you are. Goodbye.
Thank you as well. I just wanted to say a quick thank you to the program, Salma. Thank you for having me, and of course Dominik for chairing this talk. And to members of the audience who ask questions, please, I invite you to write to me directly if there's, and let's have a conversation. But yes, thank you to all, and stay safe. Thank you.